Okay, good afternoon, everyone, and thank you for being here for the last panel of the day.
Try to pull this up as you're doing this.
Yes, do that. My name is Johanna Helgen. I'm a research fellow here at the Quattrone Center, and my research surrounds plea bargaining, which is what this panel will be about today. And I think this is a very fitting topic to end the symposium with. As I think most of you are aware, our criminal justice system today is not a system of trials, which is what kind of the lay public would assume, but it's a system of pleas, with 97–98% of all criminal cases being resolved through pleas. And as we can probably all here agree, the plea bargaining process as it is practiced today is very opaque, inconsistent, and can be very unfair, especially for marginalized communities, which we heard a little bit about earlier today. It's also a very coercive practice. I like to tell students that in interrogations, right, police officers offering leniency to a suspect is illegal. They can't say, hey, just tell me you did it and I will give you a lighter sentence, because that is coercive. It's too coercive. It's illegal. But that is the whole basis of plea bargaining, and yet it is allowed, and it is what we use for most criminal cases. This is also why plea bargaining is a big aspect of wrongful convictions. And if we look at the National Registry of Exonerations, we see that about a quarter of those people who were wrongfully convicted initially pled guilty to these crimes that they didn't commit. So despite the widespread use of plea bargaining, it's only relatively recently that researchers and to some degree courts have started to realize how important it is to study and pay attention to plea bargaining. So that's what we're going to talk about today. I'm very excited to have these three incredible women with me. They're going to introduce themselves a bit more when we start talking, but we have Jenny Roberts, Taya Johnson, and Rebecca Shaeffer. So they are all associated with the Plea Bargaining Institute, which again we will talk about more today. But it's a great project that very recently started, and I think the goal of the Institute is similar to what we've talked a lot about in the symposium, and what the goal of this panel is today, is to share and solicit data and research that can help inform law and policy changes, and to promote the sharing of knowledge and create opportunities for dialogue that will inspire new and innovative research. So without further ado, I hand it over to Jenny, I think. Are you starting?
Okay, I don't remember, but that's fine. Okay. Hi, everybody. So I think I'm supposed to start by just giving a little bit of an introduction of myself and my own background, so I'll keep it really short. I am a professor of law at American University, Washington College of Law, and I co-direct our criminal justice clinic. So it's a misdemeanor defense clinic, although during the pandemic we did compassionate release under DC's then new DC Compassionate Release Act, and so we got about 12 people released. Others died before being released, other of our clients during the pandemic, and we still represent a lot of those clients in reentry and other related issues that followed them out. I taught a criminal defense clinic at Syracuse out of the Onondaga County Criminal Court in lower court there for some years before moving down to American. And our clinic is in Montgomery County, Maryland. And I was a public defender in Manhattan, where I grew up before that. And I also teach first-year criminal law, and my research is in the areas of, I write a lot about misdemeanors, which is the criminal legal system, and I write about plea bargaining and collateral consequences of criminal convictions, and a little bit about expungement and criminal records, and teach about all those things. So I think my charge today was to talk a little bit, although I'm going to keep it short because I think I'm more interested in the Q&A. Hopefully people will have questions. But talk a little bit about what I see in practice and what's not reflected in sort of academic research. This is, where the institute that we're all part of now has a lot of space to work in, and maybe talk a little bit about my own research. So just generally on plea bargaining, one thing I would like to say is there's a lot of research out there already on plea bargaining, and like many things with the criminal legal system, it's using the research to change things that are wrong, which is the real challenge. We can study things to death, and it's very interesting for us academics to continue studying things, or study something that we all, have a very strong sense about already. And of course, there's a role for that, and it's important. But you can have very, very clear research on something, and it will get you nowhere if people aren't motivated to make the change. And so I think that's the much bigger problem, sort of how do we use this? So, just a couple of examples. So if you look at the academic literature on plea bargaining, commentary, journalism, just everyday conversation about it, to the extent there is, it's good or it's evil, but very often you hear it's sort of, it's necessary. So you might think it's a necessary good, you might think it's a necessary evil. That assumption about plea bargaining rests on the assumption that we have to have a criminal legal system that is as overloaded, crowded, enormous as it is. And that's a really fundamental part of our system that this should be said every time we talk about plea bargaining. Plea bargaining is not inevitable. It is only inevitable in a system that is exceptional as ours is in the worst of ways by being much, much bigger than any other criminal legal system in any other place on earth. You can correct me if I'm wrong about that. We've got the real expert on that over here. And so I think, I really just want to start there, resting on that assumption. There was and this is particularly true in the realm of misdemeanors, of course, because the vast majority of all criminal cases are misdemeanors. 80% in most jurisdictions, nationwide, 80% are misdemeanor cases. So how do we use research that we have on plea bargaining in our actual practice or to make actual change? I want to offer one example of something that just happened in our clinic, which was we started it in seminar in class, and it's a class that's called Anti-Racism in Practice, and it's giving the students readings about racial inequalities in the criminal legal system. Take your choice. There's a lot of readings. One of the readings we use is Carlos Verdejo's article on racial disparities in plea bargaining, because, again, plea bargaining is what's going on. And so that we talk about that in class, and then we talk about how do you actually use this? How might you put this into practice? And we kind of moot it in class. Well, as it happened, a team of my students had I think 13 hours of body cam. Body cam is killing me because I have to watch it all too in all of our cases. So they watched every minute of it, and it's so many hours because there were like 6 officers at this scene, and it was a car stop, and the driver was the only white person in the car. Our client was African American, as were 2 other passengers. The driver was visibly drunk. There was an open container at his feet. He was the only person not put in handcuffs, and he was allowed to drive away in the car. All of this on body cam. The 3 black passengers were pulled out, immediately handcuffed, sat down. Every single thing was searched and attributed to them. So it seemed to the class in our seminar that this was an opportunity to negotiate. Now this is, in misdemeanors, in my view, the only negotiation with the prosecutor is dismiss the case. Unless there's some kind of immigration safe or housing safe plea, you're looking to avoid a collateral consequence where if you don't get the dismissal, it's better for your client to take some other kind of plea than what's on the table. But putting that aside, you're negotiating for dismissal. Otherwise, why would you not be going to trial? Now, there's always exceptions to that, and it's always up to your client, of course. But that's another thing about plea bargaining, which I really try to impress upon my students, which is one might say that your client is making a choice. They can choose to take the plea because They want to get out of there. They want to go to work. It's better for them. They're getting a good deal. In the lower criminal courts, it's rarely a good deal, whatever plea is on the tables, and that's based on my decades of experience in a number of lower criminal courts, but also the research. It's rarely a good deal. And so are our clients really making a fully informed choice about what the best thing is? Usually not. In most cases. I hope our clients are, because my students have like one client at a time, so they have a lot of time to counsel them about what real choice is on the table and what actual consequences will come for the rest of their life from one misdemeanor conviction in every pretty much aspect of their life. But in a lot of cases, lawyers just don't have the time. Why? Just to circle back, because the system is so huge that everyone has so many cases that you can't actually give someone a free choice. All right, let's see. Maybe I have other stuff. I'm going to stop there.
Okay, thank you.
I read one bullet point and then just went off on a tangent.
And I think then we're going to go.
Okay, great, wonderful. Well, I will just stand up so I can use the screen here. So, well, wonderful. I'm so thrilled to be here. I'm Taya Johnson. I'm a professor at Rutgers Law School right across the river. And besides being a professor, I'm also the reporter for the American Bar Association's Plea Bargain Task Force. And so that's really what I want to talk about today, is sort of focus my remarks on the efforts of the Plea Bargain Task Force, what we've been thinking about, the principles we came up with, and then maybe ways it could help people in this audience. And so a little bit about the task force. The idea was essentially that there was a lot of critique of the police system. I'm sure for many people in this room, right, have critiqued the police system. I certainly have in my own scholarship. And, there's tons of study on it, but we wanted to really sort of take that study and bring it all together in one place, do a deep dive into what are the problems with the police system, what are some of the starting points for solutions, right? Not like the solution, because that's obviously pretty broad. But to do some consistent study and then produce a report that was not just for academics, in fact, was really largely for practitioners, for judges, for the public, so we could have a starting place to talk about plea bargaining. And what we did after almost 4 years of study, I joked that I was pregnant when we started, and now I have a very misbehaved almost 4-year-old, and we just produced the report. So he's been on this journey with me. So we came up with 14 principles, and I wanted to just sort of start out by talking about the first principle, which I think is sort of the umbrella principle for the report. And hopefully people can see it up here. I know this is not an ideal slide. And so the first principle is a vibrant and active docket of criminal trials and pre- and post-trial litigation is essential to promote transparency, accountability, justice, and legitimacy in the criminal system. And we started with this because we wanted the premise to be that trials are important. They further these fundamental values in an adversarial system. And one of the big issues with a system that is controlled by plea bargaining, as Jenny said, where we think plea bargaining is necessary, is we don't have trials. And so principle one really, sort of focuses us on the idea that part of the goal should be to get to more trials. And I won't go through all 14 principles, but I also just focus here on principles 2, 3, and 4 are fairly specific to what we call the trial penalty. Again, I'm sure many people here are quite familiar with the concept, but the idea is why do we not have many trials? We don't have many trials because often plea bargaining feels inevitable. It feels like the only choice. That what we talked about in the task force is some coercion is necessary in the police system because the state has obviously arrested a person and has some power over them. That's necessarily coercive. What we're sort of concerned about is impermissible coerciveness. Coerciveness that overbears the will of the defendant, to use language from the Brady case at the Supreme Court. And so, we talk in principle 2 about we want guilty pleas not to be the result of this impermissible coercion that overbears the will of the defendant.
In principle 3, one source of that coercion is what's called the trial penalty. It's the differential between the pre-trial offer on the table, the plea bargain on the table, versus the sentence one will get once they've been convicted. And while we understand that some differential is, necessary for the functioning of the system, what we often see is sort of these huge differentials, and the concern with those huge differentials is that they are coercive. And principle 4 can sort of be read along with 2 and 3, the idea that we don't want prosecutors to seek enhancements, to seek higher sentences, to seek collateral consequences with the purpose of encouraging a plea versus allowing a defendant to go to trial, right? That we want people to be able to go to trial. I won't go through the other ones, but I'll just tell you, the other ones are quite broad. We talk about the need for defendants to have access, meaningful access to counsel, so that they can actually discuss the plea offer on the table. We talk about the need for discovery, right? Discovery reform. We talk about bail. We talk a lot about data and the need for more data. And so, I think, not surprisingly, right, that, what you see in this report is that we're talking about things that we could think of go well outside the scope of plea bargaining. And I think what we discovered is plea bargaining is not really just about plea bargaining. Again, as many of us probably know, it's really about the whole criminal system. So plea bargaining really touches everything, and it's influenced by mandatory minimums. It's influenced by collateral consequences. It's influenced by discovery rules. It's influenced by the robustness of defense counsel or the lack thereof. And so I think one of the interesting things for us is in thinking about the problems with plea bargaining is that sometimes it's hard to identify the problem because plea bargaining touches so many areas. And I'll just direct people to, there was a very interesting debate in the pages of the Texas Law Review just last month between Professor Jeffrey Bellin, who I think is at William & Mary, and Professor Carissa Hessick at UNC. And they sort of had this debate about, what's the problem with plea bargaining? Is plea bargaining, sort of causing the problems we see in the criminal system, assuming we identify them as problems? Obviously, I'm speaking about it in a particular way. Or did plea bargaining kind of create those problems? And does that matter to how you think about plea bargaining? And sort of I saw their debate as an interesting kind of, what came first, the chicken or the egg, sort of conversation. And one of the reasons I thought it was such an interesting conversation is because I think in the task force, that's sort of what we have been confronting, right? Did plea bargain cause the systemic issues, or is plea bargaining responding to systemic issues? And of course, it's both, right? That there's, at least in my opinion, it's both. And so I think our principles reflect the broadness of the issue. We certainly have many principles in here that are very plea-focused. For instance, we have a principle that we want more transparency and sort of kind of more robust procedures for the actual guilty plea. But then, of course, what you see here also is things that, go much outside the scope of just, the taking of the guilty plea. Lots of conversations about mandatory minimums in the report, and the majority of task force members, who I should say, I meant to say at the very beginning, represented both sides of the adversarial aisle. We had defense attorneys, we had prosecutors, policy makers, academics, a judge. So we tried to have sort of a broad swath of representation of viewpoints within the criminal system. And so we had conversations about mandatory collateral consequences, mandatory minimums, and things like this, because, of course, what we found is, they certainly influence and often distort the plea system or the negotiation that takes place. And so I think the conclusion we came to is ultimately there are a lot of benefits to plea bargaining. and they make sense in moderation, but that we don't do plea bargaining in moderation anymore, which I think actually was Rebecca's line in one of our meetings many months ago. She may not remember, but I loved it, and I put it in the report, that we don't do plea bargaining in moderation. And I think we're trying to ask in the report is, how do we get back to a place where the protections we envision for the adversarial system actually have teeth? And the overarching message of the report is that we have a system that we have now, that we have to attend to the realities of that system, but we also should be thinking about the system we aspire to. And when part of the hope of this is to say, where do we want to go without just immediately the sort of knee-jerk reaction like that's too expensive, that's impossible, that you have to have some vision of where you want to go. And so I'll just end on this as my pitch. I personally, and I'm sure many members of the task force, but I only can offer myself up, if anyone in here wants to have longer conversations about the task force report, I mean, certainly we can have it in Q&A, but I'm available to have brief, extensive conversations. If you're, a defense attorney and want to think about how to use the report in litigation on plea issues, I'm available. If you're a judge or a prosecutor or a policymaker who wants to think about how to create fairer courtrooms, I'm certainly available, because I think our hope is that, and this is true of the Plea Institute, it's true of sort of a lot of the efforts that are happening right now. It goes back to what Jenny said. We don't want this work to go nowhere. We want this work to have meaning, to have legs, and to, help people who are sort of in the field make change. So, okay, thank you very much, and I'll close this down.
And finally, we have Rebecca.
Hi, I'm Rebecca Shaeffer. I'm the legal director for an organization called Fair Trials International. We're headquartered in London. We have a big office in Brussels. I started an office in DC in 2016, out of which we do work on the USA and Latin America. It makes it sound like we're really big, but we're really not that big. We just have a really big mandate and offices all over. So I want to talk primarily about the Plea Bargaining Institute, which is a project of Fair Trials, and Professor Lucian Durvan, who I know was dying to be here and couldn't be here because he's in Australia. It's a partnership between us to create a sustained home for basically research and action, thought leadership, collaboration between researchers, practitioners, and policymakers in the area of plea bargaining. I'm going to talk about it in depth. You're going to get a preview of our unpublished website. It's going to be really fun. But first, I just want to talk to you a little bit about how I came to this work. So I was working in Europe, like in Brussels and London, with Fair Trials, working on passing a package of procedural rights bills at the European Parliament. And when laws get passed in the European Parliament, it means that they have to be applied, or this kind of law called a directive, has to be applied in the domestic law of all of the European member states. So it's super powerful. And I got really high on law reform. I was like, this is so powerful. Here it's municipal, there's a court rule, everything's so tiny and fragmented. But there I was like, wow, this is so powerful. We can change the laws for millions of people with the stroke of a pen. And it was a really exciting time for law reform in Europe. And the idea that the European Parliament had was that there's all these decisions from the European Court of Human Rights on procedural rights, criminal procedural rights, but they weren't being well applied by local domestic courts in European member states because who reads French really? Polish, a local Polish judge is supposed to read and interpret the jurisprudence of the European Court of Human Rights. So they decided to make really easy to apply codified standards for criminal procedural rights that would apply across the EU. So we got access to counsel upon arrest, prior to and during interrogation. That's the law of the land off the European Union. We got access to information, including discovery, including prior to interrogation. Some discovery has to be given. Super powerful procedural rights that went beyond the standards of the Constitution of the United States. It was super exciting for me as a young lawyer who'd been educated in the U.S. And we also, while we're doing this policy work at the European level, facilitated a network of defense lawyers all through the European Union called LEAP. It's a stupid name, but it's what's called. We would talk to them about how are these laws being applied in practice? Are you seeing these new powers and these new tools? And they were it depended. I don't want to They're powerful laws that I believe in, and I do a lot of work with. They're really important laws, the European directives, procedural rights directives. But the lawyers, like some of them were like, I don't know, because like actually minor offenses aren't covered, and also we have this like new abbreviated procedure where like there's not really a trial. And I was like, what? Excuse me? That sounds familiar, you know what I mean? And it was really, that was quite new as well. So we almost simultaneous with these new super strong procedural rights coming into force, you had these new forms of like trial evasion coming into practice in a really quiet way. And that's just like a picture that I want to paint for you, because that's really what I think the work of the Plea Bargaining Institute and all of our work is trying to do. Like there's just such a gap. It's so disheartening to do all this law reform and then the practice is just like over here, you know, and you're taught about the beautiful guarantees of the Constitution and reading all this like jury, you know, research, and that's not something that you ever encounter in your career, and it's just such a gap. But in that gap, I think there's a possibility. What arises, I think, is the possibility for empiricism, phenomenological research, observation, and collaboration. And that's what we're trying to do. Like, what world are we really living in? All right, let's stop telling ourselves stories and start talking about the world that we're really living in and the world that we want to live in. And that's like the metaphysical version of the Plea Bargaining Institute, I think. So what I ended up doing was, okay, I was like, well, we need to like track where these trial waiver systems are happening, because it seems like they're like called different things, and they're coming in kind of quietly, and they're used in really different ways. So we ended up at Fair Trials doing like a global survey to see. We had to like come up with a definition of what counted as what we call trial waiver systems, because if you call it plea bargaining, everyone says they don't do it around the world. So we call it trial waiver systems. We defined it. We surveyed 100 countries, saw who had them, when the law came into force, what the law said, and then we surveyed defense lawyers, prosecutors, judges in those countries to see like what it looked like if it was actually being used. And we saw that the incidence of laws authorizing trial waiver systems increased like 300% over the course of 20 years. It was like boom, all of a sudden everywhere. I don't want to get too caught up in that, but that's the first research we did, and you can read about it in a report called The Disappearing Trial that we published in 2017 that has like pretty maps and stuff. Like I'm really proud of the footnotes, but it has pretty maps that if you just want to not read the footnotes and see how the growth of the practice happened worldwide. And at the same time as we were doing this sort of global mapping, you start to see, like I'm not an academic, I'm not even a practitioner, I'm like in this weird, you know, like what's research, like research for policy. It's like just enough evidence as you need to like shock someone's conscience, you know. That's the world that I'm in, you know. And back then we had the RCN network that Alison Redlick, who's involved with the Plea Bargaining Institute, and Sean Bushway facilitated, and they invited us to come talk about it. And I was like, well, this isn't really this isn't like research, you know what I mean? But they were super interested, and psychologists and economists and like behavioral economists and people who were developing apps to replace lawyers were like all there, you know, sharing information, and they were really interested, and it made me feel like, okay, there is a conversation here. I don't have to be like an academic. I don't have to have a PhD in criminology and like understand how statistics work to engage in a conversation. Because what we're really talking about is, what are we doing? Like, what does it look like? And like, what should it look like? It's, you know, so that made me start to think, okay, there is room for all of us to be talking more. And the only reason we even recognized that this was an issue in Europe, for example, is because we were talking to practitioners. We were very proud of the new laws that had just been passed, and we were like, check, 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 success. And practitioners were like, it's not really going to change that much. So even that conversation and the value of collaboration and multidisciplinary approaches is important all the way through this, because if you just looked at the papers, you would actually never even know that plea bargaining was a feature of U.S. law, but it is all of it. Okay, so at the same time as we were working at Fair Trials on the disappearing trial, you had coming out of civil society space, which is where I live, Human Rights Watch had a really groundbreaking report in like 2014, I think, that's called An Offer You Can't Refuse, which is about the plea bargaining, the trial penalty in federal drug cases in the USA. And it was the first time that I had read human rights people like me acknowledging that this was a phenomena that undermined what we understood to be fundamental rights and harmed people. And then the National Association of Criminal Defense Lawyers came out with their report, The Vanishing Trial, which had a more like Sixth Amendment lens on things, and they're working on state reports now too. So it was just like this coalescence where everybody started saying the thing that was unsayable, which was that like, this is what it looks like. It's pleas, not trials. And then you started to get the case law too at the Supreme Court that started to say it. So that's been sort of building for a while. And at the same time, then the ABA task force happens, and there's just like obviously a growing movement in the academy and in policy spaces and in the news. There's a growing recognition about what's going on and a growing ability to like have the language to talk about it, which was a thing at first. And at first it's like, it is this like, it's a problem with no solution. There's no policy fix. Anything you think about that could, for example, reduce the differential, the sentencing differential, could take tools away from mercy from the defense, and that feels scary or potentially dangerous. Like it feels really hemmed in when you start to think about policy fixes, which can be really overwhelming at first. But I do think we're starting to move through that, through collaboration, through the fact that we have policy people in really deep conversation with the federal defenders or state defenders to say how can we craft this so that we limit the coercive impact of the trial penalty without reducing your avenues for mercy and flexibility. It does take that level of collaboration. So this year, I guess I'll go up here. Professor Durvan and Fair Trial started this Plea Bargaining Institute. This is not the public website. There's a public website. You can just Google Plea Bargaining Institute and get to it. And you should go to it and you should sign up for updates because a lot of you are going to want to be involved. It's really nascent. We're having this is our first year. We have like a task force, which like half the people here are on. Advisory board that everybody here is on. And the idea is that we're going to create annually a compendium of leading case law on plea bargaining, because like part of the like lack of transparency around plea bargaining is like cases are not reported. Who knows? Like it's actually hard to like do legal research in the area of criminal law, and also like our appellate law is really impoverished now because nothing gets litigated, and you have this like these wacky outlier cases creating an appellate law that like aren't the reality of what most people face. So I think we have to rethink what legal research looks like, and then we have to combine it with in greater conversation with empirical research, because as I said before, we're talking about like, not law, just vibes. Who says that? The Strict Scrutiny podcast always says, no law, just vibes. Like, it's a little bit what we're working with. It's empiricism. It's what happens. It's phenomenology. It's not exactly law, right? It's just like, what do prosecutors do? And, that's kind of what the law is. A little bit. So it's a way of changing how we think about legal research, and then changing how we think about the use in legal circles of empirical research, because really that's the world that we're living in. So what we're going to do every year is produce a compendium of the leading cases that we can find on plea bargaining, so that a sort of law of plea bargaining, such that it is emerging, is easier to see. And so, there's not a lot. The cases aren't necessarily great, but we think it's useful in the beginning to collect them. So we're aiming to have, in the fall, we'll have a report each fall. We think of the leading cases, trying to go for about 50 to not overwhelm people on plea bargaining, with like some analysis and like thinking about what this tells us about how courts are looking at plea bargaining, whether they're starting to think about the trial penalty, how they're thinking about plea bargaining, if that's starting to change with this growing recognition of the fact that this is the world that we're living in. Are they ever looking at research on voluntariness, for example? Are they considering psychology research? Are they considering all the work that people are doing? Is that filtrating into courts at all? And then the other publication that we'll make every year is just a collection of the multidisciplinary research from psychology, from economics, from wherever it comes, and from law. But people can find that more easily. Like, it's actually hard to find social science research if you've ever tried. Like, it's a lot behind paywalls and stuff like that. So what we want to do is summarize that research for you, so you don't have to like pay for 1 million academic reports that you don't have. And what it's going to look like, it's also going to be searchable on this website. I just have two, this is just a sample of what it's going to look like. Like we just have for case law, we just put Brady in there. So you'll be able to search by like key term. If you're like, I want all the cases that talk about, you know, that use the word coercion, or all the ones that talk about voluntariness, the ones that involve a co-defendant this has. So we have a bunch of search terms that you can use. We also code by judge and jurisdiction, by sentencing differential, if you want to do just sentencing differentials involving death, involving 10 years or more. So we try to make useful search functions. So we'll publish them every year, but really we think the website is what people will use. And at first, the first year, it will just be like, we're going to do a little look back on the leading cases thus far, and then every year we'll add about 50 cases. So it should be quite a lot and quite usable. And then alongside it, we have, this is Lucian's research, that's why we can put it up here. Summaries, including key quotes of the leading research involving plea bargaining, just so it's really easy to use, so that lawyers can use the research without too much trouble, and we can do research on plea bargaining more easily. So that's like the public offering. And then at the same time, we're going to meet every year, depending on funding and logistics and things like that, how many of us can come together every year and meet in working groups. We try to have both on the task force, what is it called? Everything has different names. On the steering committee for the Plea Bargaining Institute, we have people, we also try to be interdisciplinary in that way. We have practitioners, policy people, academics there. They're each going to have their own working groups for their own kind of people, so that they can develop their own thinking, and then we come together every year and share. And the idea is we can come up with common research agendas. We're it's not just researchers being like, oh, this is interesting, or law professors being like, oh, this is interesting, but actually what's going to move the needle? What do we actually need? What's the actual where does empiricism matter? Where is it going to move the needle in litigation or in policy? That's what we need from researchers. Or letting litigators and researchers sort of brainstorm together about what kind of evidence and expertise is available out there, how it could be used in strategic litigation. So there's an in-person collaborative component to it. That's probably a smaller number of people, but we hope that this will be useful to any litigator, any policy person, any researcher anywhere. Before I stop talking, I'm just going to mention one other thing, because I know it's oh, a think tank, okay, but it's not the only thing that's happening, and it's happening alongside policy work. So there's the End the Trial Penalty Coalition was recently launched. This is an initiative facilitated by the National Association of Criminal Defense Lawyers, but including all of these people, bipartisan, across the country, all of these organizations getting together because we all agree that there's a problem with plea bargaining. We need policy solutions. So we do have a policy coalition also that's working on policy. The Plea Bargaining Institute piece is really to advance research and collaboration with an eye of impacting policy. And there's a lot of crossover, as you can imagine, between the folks involved in those things. But I just don't want you to think that I am laboring under the illusion that coming up with better research is going to change what our legal system looks like. And as you heard in the beginning of my talk, I also don't think that legal reform necessarily changes what happens on the ground. And that's why we need all three of those groups in the room all the time. So that's the idea.
Thank you all so much for that. We have a lot of time for questions now, which is great, but I'm going to use my power as the moderator to ask some of my own questions first. So I know there are practitioners in the room. We've had both the defense side and the prosecution side here the whole week. So I wanted to ask all of you, what role do you guys think that defense attorneys and prosecutors have in trying to change the plea bargaining system and improving it on a sort of individual basis?
So I'm going to answer and use this opportunity. I realized in my rush to not speak too much so that we could get to Q&A, I didn't tell you the end of the story. So I know you've all been on the edge of your seats wondering what happened in that case where my students wanted to bring out racial disparities. So this is a story of individual case defense lawyer, prosecutor, judicial responsibility in the plea bargaining process. So that my students, armed with this discussion and seminar and the Verdejo study, go into court, and video of this extreme different treatment based seemingly solely on race. There was no other explanation because the officers didn't know anyone involved, and that was the only distinguishing characteristic. Go into court to say, hey, our client charged with this 1 pill of oxy, yes, 1 pill of oxy, big case in Montgomery County, Maryland. You should dismiss this case, in part because of the racial disparity. The drunk driver with the open container at his feet drove his car away and went home, and our client did not. And so the prosecutor, unfortunately, the prosecutor's response was, that is irrelevant to me. I can prove my case, and we are going forward. And that was a very disheartening and hopefully wouldn't be the response of every prosecutor. It often is in our jurisdiction. It was, but hopefully that wouldn't be the case everywhere. But then the students had this dilemma of what else can you use this for? And we had a very long discussion in class of how hard it is to work the empirical evidence about racial disparities in plea bargaining into any other part of the process. How do you get the judge to listen to that? You're not supposed to talk about plea bargaining when you get to sentencing, right? And they masterfully worked it into a constitutional speedy trial motion, which if anyone's a defense lawyer, you don't win those. My 2 students won a constitutional speedy trial motion on this case right after the prosecutor slammed the door in their face. So that was particularly satisfying. And they managed to work that in, even though we had already decided it had no doctrinal place in the argument, but the judge had to hear it. And so, you work with sort of what you have and you try to work these studies in. But, in terms of what the responsibilities are in plea bargaining, defense lawyers don't use this evidence enough, and they have a responsibility to take it and use it. But you have to be careful because it can be used the other way against your other clients, right? And prosecutors absolutely have a responsibility to be aware of what the data is in their office, and to not just pay attention to it, but actually obliterate racial disparities in plea bargaining and sentencing in any approach in their jurisdictions. And judges, of course, also have a big responsibility here.
Sure. So I would say one of the things that I think is important is just, well, it starts with Jenny's point about we sort of think plea bargaining is necessary. And part of that is just a cultural, part of the culture of being a defense attorney or a prosecutor. And I used to be a defense attorney, and I think that very much I used to have that sense of, this is just necessary. We must do this. And also a broader sense that the system we have for a reason, and somebody before me must have come up with reasons for this that make sense, and I should then accept it as a new lawyer. And then the group of lawyers who comes up after me feels the same way. And I think that one of the things we should just be mindful of is the role of culture, the role of you do things the way you've done them before because it's comfortable, because of inertia, and it is why when the plea bargain task force report came out, I was interviewed for the New York Law Journal, and they also interviewed a defense attorney and said, "Yeah, looks great, never going to happen," and it was such a great comment because it was like, "Mwah, of course, right? Like read the report, think it's all great, never going to happen." There has to be some way you break out of that mindset, right? I mean, if the problem is that it's all the problems we identify, but then the solution is like, well, there is no solution. This will just be it until, the earth just, burns up. It's like, well, how could that possibly be the solution? There has to be at least some sort of creative energy that you put towards rethinking the way you do business, even though, yes, it will be hard and it will be expensive and there will be all these issues that come up. I just think that that folks on the ground, and I used to be one of them, and I know that there's a benefit certainly to no longer, being on the ground and being in academia, but just sort of embracing maybe things should change and that I have sort of cultural norms that are embedded that I have to work against. And I think that's kind of for prosecutors and defense attorneys a hard thing to do, but something that could make concrete change.
So I think there's a lot of really specific policy guidance in the principles, in the ABA task force principles for prosecutors and defense lawyers and judges to a certain extent, although they've made themselves rather irrelevant by approving all plea bargains, you know what I mean? But no offense to judges, yikes. And then we've also produced a brief with Fair Just Prosecution, who's here, also, hi Anna, on advice. Here's some advice for prosecutors on how not to abuse the plea system. There's guidance out there. There is more and more we're able to create specific, ethical actions that are absolutely within the scope of power that prosecutors and defense lawyers have. They can change the way that they're acting. There's nothing compelling them to act that way except peer pressure, basically. Received assumptions about how we should act. I would also say, what helps me is the fact that I do international work and I have all this comparative, and I'm like, it definitely does not have to. This is not the only way that things go down. Not at all. And even looking historically can give you that same kind of perspective. You can look at different times and different places to expand your imagination. And I think there's a lot of thought, around abolition and everything that's really future looking, that's utopian, but there's also a lot of data and a lot of imaginatory, I don't know what I'm talking about, visionary, there's a lot of visionary material available to us in the here and now, from different cultures, different places, different times. And, I think it speaks to the stress that people have, the professional stress of those careers, that it's you got your head down, it's really hard to step outside and think that there's a different way to do things. And again, I return to it's really great to have practitioners in policy, in conversation with policy people, and conversation with journalists, and conversation with researchers, because we do get siloed. We all get siloed and think this is the only way things can be, and it hasn't always been this way. It doesn't have to be that way. We have a ton of power. We have so much power.
Yeah, this gets to, I see some hands, which is great. I just want to follow up on that. This gets to some things that you've mentioned. And I know as a researcher in psychology and law, researching plea bargaining, we do our research, we're in our own bubbles with other people who do that research, and we're like, this is great research, but who is it getting to? So how do we bridge that gap? How do we get it to the practitioners, the policymakers, the people who can kind of actually make the change that we find in the research that we need to make?
Yeah, I think you got to get it into law schools as to start, because then they go out and they become the junior lawyers, and then they become the trainers in their organizations. Ron Wright, who's a professor at Wake Forest, we did a study together where we surveyed more than 500 defense lawyers on plea bargaining practices. And, we were surveying the defense lawyers themselves, so caveat all the researchers. We know there are issues about asking people what they actually think and what they think they do, but given, all that said, the first paper we published was training for bargaining, and it was all about, and this one's pretty clear because we could look at some of the training materials. The survey showed nobody got any training about plea bargaining, and so I started teaching a plea bargaining seminar, which I then passed on to someone else. But some of the literature, including the psych literature on plea bargaining, some of the studies that I've already talked about, we're giving those to students, but not just saying read it and talk about it, but let's get on our feet and try to use it. How are you going to introduce this? What are you going to make of it? And then they're going to go out into the offices, public defender offices, prosecutor offices, and hopefully, it kind of filters up that way. So I think you start with law schools.
Sure. I mean, I would say, part of the reason I offered to talk to anybody who wants to talk about the plea bargain task force is because I think we have collected a huge amount of data and well, not data, I would say, but I have like a massive spreadsheet with all the things that we relied on in making our decisions. So I want to talk about the principles and the report itself, but also how else might we be able to help and what other sort of information might practitioners need or want. And I will say, I do think that I would imagine there are probably people in the academy who think that's not maybe the role of a professor, right? And it is a particular view of a professor, and I think partly because I came from practice, I have much more of a sense that you don't want to write with a particular outcome in mind, of course. I think that's wrong, but that you want to write things that are useful. Or I do. I actually think that it's amazing to write something that's not useful in any, and so I don't have any issue with that. But for my own work, and so I think it's being very willing to get it out there. We just heard from Radley Balko. If there's any way to get it into sort of media, right? There's a way to get your work to journalists, and journalists can write about it, and I think that's incredibly important. So it's thinking about all the different methods you have to get people actually reading your articles, because of course otherwise law review articles, I joke, not even my parents read my law review articles, so nobody reads law review articles, so you have to figure out how to get people to be interested in the topic of law review articles without saying here, read this 80-page paper in the Ohio State Law Review. No one wants to do that, except for us, right? Yeah. So I think there's a lot of different ways to do it, but I also think it's a particular vision of what an academic is, that there might be debate about whether that is the role of an academic, but I think it's one of the reasons to partner with policy and to partner with the ABA and to do these things if you have that vision of what an academic does.
You just pick the excerpts. You can get things down
That's
really
right.
much shorter than they're written.
The Cliff Notes version, yes.
Yeah, that's whatever. That's why we have the Plea Bargaining Institute is to have these conversations, to see how we can make research more applied, to make courts care more about evidence, about reality, to make policy more responsive to the realities that people are living in the criminal legal system. I don't think it's a set path that already exists. I think we have to sort of make the road by walking a little bit.
Okay, great. Thank you so much for that. And I think we're going to open up for questions. David. Yes.
First, actually, thanks. Let's say thanks to Paul, John, Melissa, Ross, and Quattrone Center for putting on this conference as usual. And this panel in particular is amazing. Thanks for moderating. I want to talk to all of you because I'm responding to your invitations. Why? I'm a person, I think, who maybe you're looking for. So I'm a professor here. My name is Kenneth A. I'm an economist. I do empirical research on plea bargaining. And so a lot of this is super exciting. I know any of what you guys talked about, these organizations. I think it's amazing. Johanna, the same issue that a lot of times there's sort of disciplinary divides. So I'm going to talk to y'all afterwards extensively. But I want to talk, just ask, and I thought also your second question was one I want to ask about. I think it's a really good one. Some thoughts on it as well. To what extent what we work on needs to be useful. We've got the buildings right around here dedicated to people doing very not useful things. To what extent it should be sort of motivated. But at the same time, I do think it is important for academics to connect with the outside world, and I do think this is a great way to do it. But I've one puzzle, I've got a smaller question for you, Jenny, but one sort of general question, which is, how do we know there's a trial penalty? This came up, I think, for most of y'all. In particular, I think, Jenny, you mentioned that plea offers are rarely a good deal,
I was talking about in misdemeanors.
Misdemeanors, okay. And that was the other small question I wanted to ask you about, that misdemeanors, this is probably better aside, it's less on this topic, but it's very curious. You mentioned sort of criminal, misdemeanors are the criminal justice system. A lot of times we ignore it. I want to hear a little bit more about why that is. But to the rest of you, I do want to hear, why do you think there is a trial penalty? How do you know there's a trial penalty?
Do you want us to call it a plea bargain discount? Would that make you feel better? Can we, is that the debate?
No, I don't care about terminology.
Okay,
Can
okay.
I caveat that? Is it a trial penalty or a plea discount?
That's what I was just saying, yeah. I think it's irrelevant. It doesn't matter because the numbers are, numbers are numbers.
How do you know it's better for a client to accept a plea offer? That's my question. Do we know?
So if you're sitting in a courtroom with regularity and you see that people who go to trial on a charge and get convicted get whacked with a sentence that is, I don't know, 3 to 4 times, I know you're an economist and you probably don't approve of anecdotal research, but if you are a defense lawyer and you're watching that happen over and over decades in every courtroom you go in felonies, I actually don't think this is true in misdemeanors, then you would be quite ineffective, probably as a constitutional matter, but you'd certainly be not what your client was looking for if you didn't give them full information about what might happen to them. They can make a choice. You can tell them you've got a better shot than that person who just got 25 years, but the offer's 5 years and you've got a hard decision to make. So I think it's sort of beyond any research study this is, I think, a real problem with empirical research is often it's done without being paired with practitioners. And so there are often, I will look at empirical research, not being empirically trained, it's a little hard for me to do the full critique, but I can often see, wait a second, they're missing a really critical aspect of practice and what happens here. And boy, I wish they had paired with a practitioner before they decided exactly how to design the study. So that's sort of a side note. In misdemeanors, and again, this is from that survey of 500 defense lawyers, but it certainly tracked with my own experience, is the misdemeanor lawyers who were surveyed reported that they generally did not see a trial tax with misdemeanors. They did with felonies, but not with misdemeanors, which leads me to part of the conclusion of why are you taking pleas in misdemeanor cases if the worst thing is you go to trial and you get the same or better sentence. And what we find in our clinic cases is, sure, there are cases, often domestic violence cases, that you do not want to go to trial on if you think there's a good chance you're going to get convicted if you're the client, right? Because the facts are going to make the sentence a lot worse. And some people would say that's not a trial tax, that's just facts that came to light that wouldn't come out in plea bargaining. I would dispute that. I think, it shouldn't be determined by what facts come out or don't come out. In a lot of cases, the trial actually makes the offer look ridiculously high. So you turn down, a plea offer in a case and you go to trial and you see the body cam and you see what happened in the case and you see all the problems. And at the end of the day, at least in our county, there are bench trials in misdemeanor cases. The judge sometimes will convict and say, but I have a lot of issues with this. And, so they call it rocket docket disposition for some reason, basically time served. So sorry, that was a really long answer. It was great. Thank you.
I think it does go to the need to be collaborating from the get-go with practitioners and with policy people. Because, for example, I don't know if it's actually a math question. I mean, sure, you can make it a math question. I don't know how much that tells you or where that gets you. I think that for me, with my bias as a human rights policy person, I know there's a trial penalty because I've seen the legislative transcripts of prosecutors going to their state legislators and asking for higher sentence regimes so that they can get guilty pleas easier. That's how I know. So you can answer the question a million different ways. You can answer with math, you can answer it with policy, you can answer it with anecdata from practice. There's a lot of ways to answer that question. And also, I would say that our understanding of the trial penalty, of what the trial penalty is, has significantly complicated, gotten more complex, richer, more nuanced in recent years because as a result of these conversations. And we understand that it's not just a question of, I mean, first of all, I also have some answers too, which we can talk about later, but I want to complicate it first. So, like, we talk about the trial penalty, if you read the report of the ABA task force, as all of the coercive tools that are brought to bear upon a person to force them to plead guilty, to put them in a position where it's rational for them to plead guilty in a situation that might be against their interests. And that includes the use of pretrial detention. That includes, withholding evidence until too late. That includes poor access to counsel. So there's all kinds of coercive features. That's what Taya was talking about. And if you read the task force report, you'll see it. It's not, yes, the mathematically, diametrically, geometrically, whatever, longer sentence that, I'm not an economist, the longer sentence that you're going to get at trial is part of the picture, but it's a mistake to see that as the only thing that's going on. And research that's not properly informed by practice and policy will get you these kinds of thought experiments that, may or may not impact anything.
Well, I'll just say very quickly to the trial penalty versus, plea discount issue,
Oh, sure.
because I think that was something we really struggled with, because defense attorneys were really like, you do not want to take this power away from defense attorneys or from defendants because then they'll be hurt, because they'll go to trial, we'll encourage them to go to trial, they'll go to trial, and then they'll get the mandatory minimum or the huge sentence after trial. And I think that one of the things that we say at the very start of the task force report is you sort of have to read all of the report in tandem because, or as a body of work, because the truth is that we want to be thinking about encouraging people to go to trial as we're also thinking about ways to make our sentencing system fairer. And I know that sounds huge and gigantic, but again, it's this sort of being able to see that if it just continues as it is, and if you think that's problematic, and of course there are people who don't, right? But if you think it's problematic, then how do you sort of envision something different? But of course, one of the issues, and one of the things we acknowledge is that like more people going to trial under the system that we have, you would have higher sentences and people going away for longer, and that defendants are getting a discount when they plead guilty. The problem is are they getting a discount from a thing that everyone agrees is fair, or are they just getting a discount from the thing that we've put in place in order to encourage them to plead? But we really do say you sort of have to be thinking of all of it at the same time, because if you only instituted certain things without other things, you might get some results that I think I would be upset with, right? Or other members of the task force.
Yes, I think.
Can I say something? I'm listening to this. I was a federal prosecutor for 14 years, and I think you're missing some of the benefits of low pressure plea. I mean, if we had every matter go to trial, the system would crumble, just in terms of time and the benefit of resources, the judges, prosecutors, it wouldn't work. I mean, I think of a particular couple of tax cases I had where before I took over the case, DOJ Washington was involved. They believe I took over the case. Millionaire defendant, lots of pricing lawyers. DOJ offered him, I offered him plea, 2 counts of 5-count tax and back. Fancy lawyer says, I'm going to trial. Fine. In the second day of trial, after killing him, I walk into the courtroom, everybody's in the back in the judge's chambers. Said, Mr. Palmer, the defendant wants to plead. I said, Your Honor, fine. He's not going to plead to 5 counts. I said, Mr. Palmer, Your Honor, he was offered to plead 3 counts a while back. The government took the time to get the trial. We're here in the second day of trial. He's going to take 5 counts. I mean, there is a benefit to you. You look at the strength of the case. The defense lawyers have to do that. We have to look at the prosecutors. I put in the time, prepare my notes, and spend the time. We're going to say, look, justice is served. You do take plea on 3 counts. Saves the court's time, the judge's time, the jury's time, everybody's time. So you choose to go to trial at that point, there's a consequence you can take. The judge is going to say, you have to spend my time, tie down my docket, bring these jurors in here. You're going to get down 5 counts.
How dare you exercise your constitutional right to go to trial? Yeah, but see, here's the thing. Your comment is, I understand where it's coming from, right? You put in the time, you put in the resources, and it was very much within the role that you had. But let's step back a second, which is the idea that we could have a system where it could not operate if people actually exercise their constitutional rights is crazy. That we could have that system, and it must be that way. You have to start, and you have to start from the premise, if you are going to have a system like we have in this country, where we have an outsized number of prosecutions. I don't know what office you were in, but I would take a guess you were prosecuting a lot of cases that a lot of people might think shouldn't be prosecuted. If that's the system, sorry, but that's true of almost all prosecutors' offices. If that's the system we have, and the answer is, well, we want to do this because we know that people are going to feel coerced or maybe want the benefit. And you can't answer me because I know there are lots of people there, so I can just say that. Let's talk after.
As a matter of practice, federal prosecutors cannot take every single case. You have the resources, right?
Okay, well, state prosecutors take most of what the police handle. I think you have to come.
Yeah, we're gonna go with the gentleman over there. Oh, woman over there.
Relatedly, I know that there are many countries which use a continental system, and there's far less reliance on plea bargaining like practice. In fact, in some of those systems, plea bargaining is but it's also my understanding that recently in a number of those countries, there has been pressure building to establish, not exactly plea bargaining as we might understand it, but kind of a similar entity, and it's thought to be in response to these kind of arguments that there's too many cases, it just takes too much time.
Yeah, like no doubt it's easier to get convictions if you don't have to go to trials. It's cheaper for the state. They can prosecute more people. Definitely. I don't think there's any doubt about that. And my report does document the spread of plea bargaining all around the world for those reasons and with the support and financing of the U.S.
My first question is that really what's driving it? Is it solely driven by
No. Okay, so there's a couple of reasons. So in some countries, yeah, it's about efficiency, right, which is a very elastic concept, because what ends up happening in countries we've seen that adopt abbreviated procedures or some kind of fast track trial is that they just increase the volume of cases that they process. And so, like, it depends on what you mean by efficiency. Maybe that's your aim. And in countries that are dealing with impunity for historic crime, I mean, you know, I'm not saying that there's never a role for increasing the number of convictions that you process as a state, but that's essentially the kind of efficiency that we're talking about, volume of convictions that you can process. I'll refrain from commenting on whether that's like a good policy aim to have. Depends on the scenario, I think. And so, but there are other countries that are introducing it for human rights-based concerns because they have long backlogs. They have long periods of pretrial detention, 6, 7, 15 years. People waiting in pretrial detention for longer than they would be sentenced for. And so it feels like a way to reduce the length of pretrial detention. And one of the empirical questions that we would like to ask with the help of researchers in these countries is does introducing plea bargaining reduce the length of pretrial detention? We don't actually know if it has done that anywhere. I can tell you that it usually increases the volume of people moving through pretrial detention. So the duration might be limited, but the total number of people in pretrial detention and the volume of people incarcerated tends to grow. So it depends on what your precise policy aims are, and you have to know that there's going to be a trade-off with volume. And that's kind of the story of mass incarceration a little bit. And so it starts there, and then they see what happens over time is they'll bring in plea bargaining for or something like that for some limited purpose, just for minor offenses, just for cases up to 5 years, or just for cooperators, or just for this kind of offense, or not for sexual offenses, or whatever. Prosecutors start to use it, start to like it, and then it tends to grow, and it tends to metastasize and take over the system. Not everywhere, but it happens quite frequently. And then you have a mass incarceration problem, because then you have the ability to... Yeah.
So thank you all so much. This is super helpful. My question is, and sort of a plea as well, would you all consider speaking to state legislatures?
Yes. We testified together once, I think.
Did we?
Yes. Culture. And what felt super problematic, particularly why was it Harrisburg, New Jersey,
It was in Harrisburg.
proud of themselves when they passed new criminal penalties, additional sentences. This sentence, we're taking care of fentanyl. We're taking care of sextortion. But really what they're doing is they're adding multiple new crimes, multiple new sentences, multiple new enhancements, and then handing prosecutors like candy gas with parole fire. And so I feel like that's the legislature is part of a missing piece of this, because as long as we keep feeding prosecutors and police, who also have those charging decisions, keep feeding them all of these tools,
whatever we do on the back end isn't going to be making much difference.
Totally. I mean, the End the Trial Penalty Coalition is very focused on state level policy, and we're trying to build capacity to speak to that. But as you note, like, and as Taya noted, with the like mandate of the trial penalty task force at the ABA, like when you're talking about things that reduce the trial penalty or things that reform plea bargaining, you're talking about sentencing reform, you're talking about pretrial detention reform, you're talking about Brady reform. Like those are the levers that put pressure on people to plead guilty against their interests and reduce the use of trials and the protections of the Constitution. So, you know, it's a bit of a job to define scope and for us to decide as a coalition, like what are the policies that are going to most impact fairness, because they're not all called plea bargaining, you know.
I'll also just note that as I spoke in November to new legislators in Arizona, and I was on a panel and reporting on the plea bargain task force, and I was on a panel with a prosecutor who was like, all of this is idiotic, and just said, and really came out sort of swinging against the report. And what was interesting, and I don't know, is, you know, whose voice do they value more? My guess is they valued the Arizona prosecutor over the New Jersey academic. And so, you know, I do think a little bit it's thinking about, you know, who's the voice. I mean, we had prosecutors who were part of our group, and in some ways I think that they're actually the people who I would like to sort of be out there beating the drum on this, because I think that just from their position, there will be more receptiveness in a certain, you know, in certain realms, right? And so certainly we're super interested in it, but I do think it's a cultural thing, and whose voices matter and all that stuff.
But I think one of the, sorry, go ahead, Jenny.
Well, I was just on that. There's empirical research after trashing it on this. I think it's Carissa Hessick and Ron Wright who did the study recently of what works in front of state legislatures for legislative change, and basically having the prosecutor, I think, not opposed is the most important thing. In favor doesn't help as much as you would think. Anyway, you should look at that. I think we might have testified in Harrisburg together on some clean slate. This was years ago. So, I mean, I've testified in Maryland and in Pennsylvania, and a couple in municipalities, but, you know, it's, I agree, I think it's the prosecutors, but I also, the levers that Rebecca's talking about are absolutely where all the action is. And so when you ratchet up sentences, so in Maryland, believe it or not, misdemeanor assault, which includes threats without physical contact, it's a 10-year. It's up to, Maryland has up to 12 years on some misdemeanors. And so, that's, I don't think, ever going to change, even though it's one of the biggest outliers it is the biggest outlier in the nation. That won't change. Interestingly, as some of you may know, one of the biggest areas of legislative change related to the criminal system is expungement. Why is that? Well, I'll tell you, when maybe together or maybe not, we testified in Harrisburg. I know I got invited because somebody heard me speak on a panel somewhere, and his son had a criminal record, and he was really concerned, the state Republican legislator who called the hearing. So when it comes on your front step, you're interested in it, and actually, because 1 in 3 adults has a criminal record of some sort, arrest or conviction. A lot of people care about that. So expungement moves, and people, you know, like to say they're about forgiving, but really we're legislating forgetting, right, with expungement. But it's very different when you're talking about really high sentences and just upping and upping sentences and other practices. There's sort of less familiarity.
But I would say one thing that gives me hope, although it's mainly just like in my mind right now, but I've got a vision, is because we do have a lot of bipartisan support on this. Like the coalition is across the ideological spectrum, and there's a huge interest from conservatives and libertarians in constitutionality. You know what I mean? So it's like the Constitution's not being used, we're abandoning it. And if we can show the ways that sentencing and overuse of pretrial detention, cash bail, and overcharging, and I mean, because conservatives and libertarians do understand overcharging, overcriminalization. Like these are concepts that work, you know, within libertarian frameworks. And if you show the way that these things end up undermining the Constitution or making it, you know, dead letter, I hope that there's a way to say, like, it's connected. Like the rule of law, constitutionality is connected with how insane our sentences have gotten.
Or maybe that they just don't advance public safety empirically, again, right? And there is research on that too.
Okay, we have a question.
About implementing the findings on. Thank you. Implementing the findings from the task force report. I know of a case where someone has been in jail almost 20 years and has never seen the discovery. Could you require, and I'm just talking about one thing, that the person have seen the discovery, that the attorney have had an opportunity to go over it and discuss it with the person who was charged and has now been in jail almost 20 years and has never seen his discovery?
Yeah, I mean, I think one of the principles in our report is dedicated to the idea of discovery, and it's not post-conviction discovery, but it's the idea that before you accept a plea, think about a plea, you have the opportunity, at least, to review the discovery that's available to the prosecutor at that moment. We understand there's, you know, a body of you know, evidence that's out there, but we're talking about the stuff that the prosecutor has in their hands at that moment when they offer the plea. And you know, we really don't see any reason why that should not be within reason available to defendants to review before making that decision. But that's not the way it is everywhere. And, you know, in fact, in most places, that's not the way it is. And so you do have people like the person you're describing who never did have an opportunity to review discovery before they made critical decisions about their future. You know, and by the way, we also want the defendants to have an opportunity to review discovery with a counsel, right, who can have a meaningful conversation. And of course, I don't know if the person you're talking about was convicted after plea or after trial, but you also have a whole ball of wax with, you know, incompetent counsel or bad counsel, because certainly if the person went to trial, their counsel should have reviewed the discovery with them and had that conversation. You know, in terms of what their options are now, I think they're limited, but our hope is that discovery is a big part of this, that when you're making a decision, the constitutional rule is that the decision is supposed to be knowing and voluntary. And part of what makes it knowing is that you've actually reviewed the documents and reviewed the evidence against you so that you know that you're making a decision that makes sense or doesn't make sense, and you can then decide, you know, what you want to do. So I think discovery is a huge piece of this, for sure.
I think we may have time for one more question. I see Paul over there.
So one of the things we think a lot about at the center is quality control measures. And so one idea that has been proposed for plea bargaining, I think it's actually at least referenced in a footnote in the task force report, is the idea of taking some randomly selected set of plea bargains and after the plea just going ahead and doing the trial to see what happens. I think one of the interesting, you know, to the point that was made at the beginning about, you know, how do we get the actual people making the decisions to see things differently, I think one of the potential virtues of that idea is you get direct experience as a prosecutor, as a defense attorney, seeing whether or not you get a different resolution. I'd love to hear your thought. Is that something you would endorse? Do you think it's completely impractical? I'd be interested in panelists.
So I would say another
that.
way to think about that, and that we have contemplated in the principles. I know that world of thinking, and I think that there's some. I mean, certainly quality control, postmortems, like review mechanisms, like availability of appeals. Maybe appeals shouldn't be so limited after a plea. Like, we do have these, we have quality control systems already. We're just not using them. So how about like limiting waivers of appeals? How about post-conviction review units are more open or more aggressive about looking at guilty plea cases, which are difficult, and exonerations not requiring DNA evidence, for example, which is not always available, for example, in misdemeanor cases or non-serious cases. Like, there's all kinds of ways to increase. We're definitely concerned with accuracy, and there's all kinds of ways that we already have to do that. And guilty pleas undermine our ability to use those tools that exist in the system for a reason. So I would say, like, let's use the tools we have. Would be my suggestion.
I mean, it's an intriguing idea. I don't think you need it to educate prosecutors and defense lawyers, though. They know what those trials are going to look like in most cases, because most cases involve sort of common issues. Judges, I don't know, maybe they need a little more educating. Sorry, judges in the room. In terms of what a particular case might look like. I mean, I think you'd have to be really careful. I think it'd have to be a jury trial, because one thing that you want to see is, what does the public actually, what do non-judges think about the evidence in this case? That would be a shame to lose that aspect of it. But to go through to sentencing, it would certainly be very interesting. Could you create an artificial world in which first the jury and then the judge did not know the plea had been turned down, so they couldn't be punitive just about that fact?